The latest numbers, more than 24 inches of rain have fallen, more than 1,000 rescues have taken place.
Flood warnings are lining up across southeast Texas, and the rainfall is lining up as well.
The flooding is widespread across Houston. Just take a look at this parking lot that we're in. The officers that we've spoken with say they've never seen anything quite like this.
That's a ruling that's going to protect people all across Texas.
What Texas conceded to in front of the Supreme Court, we're going to win.
A recent unanimous ruling by the Supreme Court, which was reached by a vote of 9-0, raised questions about the viability of challenges to states that pass illegal rifle mag bans. Supreme Court ruling. We need to discuss a significant ruling that the Supreme Court handed down recently, a 9-0 unanimous ruling. This ruling has significant ramifications for numerous state laws, including those pertaining to cruel mag bans that contain unconstitutional mandatory confiscation provisions. The case we will be discussing in this video is DeVilliers versus State of Texas. This case deals with the right of individuals to bring a direct lawsuit against a state for violating the Fifth Amendment taking clause. The taking clause is a topic that frequently comes up in court cases, particularly those involving challenges to state laws pertaining to the confiscation of arms and mags. Provisions that are challenged essentially as unconstitutional and as unconstitutional because of a taking by the government and a taking without just compensation. Now they're also often challenged under Second Amendment grounds, but taking clause is another thing that is often tacked onto those lawsuits we have seen in cases like the Duncan, California mag ban case that courts dismissed those claims because they believe they're invalid. This case essentially sought clarification from the Supreme Court on whether the taking clause in the Fifth Amendment is self-executing to the point where individuals did not need express congressional authorization to sue a state, and federal courts, in this case the Supreme Court, avoided that issue once again, and it creates a lot of issues and some potential fallout going forward in other cases, including 2A cases, when the takings clause is brought up. Now, to give you guys some context and some background on what this case involves, so you understand what is implicated and what could happen going forward, this case arises out of the state of Texas installing a roughly 3-foot-tall barrier along a highway median, essentially to act as a dam and prevent stormwater from covering specific areas of that road, and that was in the Houston area. In August of 2017, Hurricane Harvey brought heavy rainfall in that area, and that new medium barrier that was put in place by the state of Texas essentially performed as intended, but then as a result, it flooded the petitioners and the plains in this case's land in a northbound area of Houston, and essentially it flooded their homes, damaged some of their businesses, ruined their crops, slayed some of their livestock, and then just generally damaged some of the property where the water was flooded into. The same thing happened during a tropical storm back in 2019, and in response, 120 individuals impacted by that barrier was put in place, sued the state of Texas.
To keep people out of rising water.
Harvey's eye cut right through here.
Been praying for quite a while now for the eye to pass over so we could get some kind of a break.
At 1 o'clock, it was terrible. It was so, I was crying, nothing left. I was on my knees praying that we made it.
Our town was destroyed.
Probably felt like 150-mile-an-hour winds. I mean, it was whipping pretty good.
Legal implications of DeVilliers versus State of Texas. In the case of DeVilliers versus State of Texas, DeVilliers, the named plaintiff, along with other plaintiffs, filed a lawsuit in a Texas state court. DeVilliers alleged that by constructing a median barrier and utilizing his property as an overflow area, the state of Texas had essentially executed a taking of his property. He argued that he was entitled to just compensation under both the United States and Texas constitutions, citing the takings clause in both. The state of Texas, as the defendant, moved to remove the case from the state court to a federal court, which was granted. However, once in federal court, Texas argued for the case's dismissal, contending that the plaintiffs could not sue the state directly under the takings clause in a federal courtroom. They argue that only certain federal statutes provided a basis for such claims, and none authorized claims directly against the state.
This is all happening right now as we come on the air, and the situation is unfortunately dire.
Harvey provoking an unfolding flooding disaster in America's fourth largest city, Houston, Texas.
Begging for a rescue.
Reports of tornadoes touching down all over the Houston area, which could make the attic a dangerous place to be.
People trapped in their flooded out homes. They are fleeing to their attics, taking to social media.
Category 4 hurricane.
Harvey likely to stick around for days upon days.
Meanwhile, this morning, we're getting a clearer sense of the catastrophic damage.
The plaintiffs, including de Villiers, countered that the takings clause was self-executing, meaning it provided a cause of action for just compensation against a state like Texas. The federal district court denied Texas's motion to dismiss, affirming that property owners could sue a state directly under the takings clause. However, Texas appealed to the Fifth Circuit Court of Appeals, which held in a brief opinion that the Fifth Amendment's takings clause, as applied to states through the 14th Amendment, did not provide a right of action for takings claims against a state in federal court. Essentially, the Fifth Circuit believed that the takings clause was not self-executing, and that a state like Texas could not be sued in federal court for a taking without express congressional authorization or statutory inclusion. This ruling by the Fifth Circuit prompted an immediate appeal to the Supreme Court. The case's significance lies in the interpretation of the takings clause and its implications for property rights and state accountability. The Supreme Court's decision will clarify whether property owners can directly sue states for taking crimes without specific congressional authorization, impacting similar cases nationwide.
Texas has pulled out all the stops to do everything it can.
Texas is not immune from the takings clause in the Fifth Amendment battle, long time coming.
That's a ruling that's going to protect people all across Texas.
What Texas conceded to in front of the Supreme Court, we're going to win.
Implications of the Supreme Court. The Supreme Court recently issued a unanimous 9-0 decision in the case of de Villiers v. State of Texas, vacating the Fifth Circuit decision and remanding the case back to the lower court for reconsideration. However, the court avoided addressing the central question of whether the takings clause is self-executing, leaving open the possibility for future legal complexities. Instead of directly addressing the issue of whether plaintiffs can bring direct federal lawsuits against a state under the takings clause, the court focused on the premise that Texas law provides a cause of action for property owners to seek just compensation. Texas state law offers an inverse condemnation clause of action, which allows property owners to pursue claims based on both the Texas Constitution and the takings clause. The Supreme Court emphasized that Texas law provides a viable avenue for property owners to seek compensation, thereby negating the premise that there is no cause of action available. The court instructed that, on remand, de Villiers and other property owners should be allowed to pursue their claims under the takings clause through the cause of action available under Texas law. While the Supreme Court's decision overturned the Fifth Circuit ruling and nullified Texas's attempt to dismiss the case by transferring it from state to federal court, it raises additional questions. Specifically, it remains unclear whether the plaintiffs can proceed in federal court with the state cause of action, or if the case must return to state court.
When I opened the door, more water rushed in, and all of my stuff flew out.
I had to save a guy's life right here. He was hanging onto a telephone pole.
Just see the water come up, making sure that all our family is safe.
All I could grab was my wallet and my phone. That's all I knew to grab.
And I got a rope. I heard him. He was out there for about 30 minutes.
We just kept looking at the water, and it just kept getting higher and higher from 4 in the morning to 7 in the morning.
Prayed a lot, and we just praised God, and we were.
Furthermore, there are concerns about the potential for procedural maneuvers by the state of Texas to repeatedly dismiss the case by transferring it between state and federal courts. This uncertainty underscores the need for clarification on the self-executing nature of the takings clause, a question that remains unanswered by the Supreme Court's decision. In the context of Second Amendment cases, the implications of the Supreme Court's ruling in de Villiers v. State of Texas are significant. Just as property owners seek redress for takings violations, individuals challenging arms regulations may also rely on constitutional protections. However, the lack of clarity on the self-executing nature of the takings clause could impact the ability of Second Amendment plaintiffs to bring direct federal lawsuits against states for alleged violations. Overall, while the Supreme Court's decision in DeVilliers v. State of Texas resolves some immediate legal issues, it leaves unresolved questions about the application of the Takings Clause and its implications for future cases, including those involving Second Amendment rights.
The latest numbers, more than 24 inches of rain have fallen, more than 1,000 rescues have taken place.
Flood warnings are lining up across southeast Texas, and the rainfall is lining up as well.
The flooding is widespread across Houston. Just take a look at this parking lot that we're in. The officers that we've spoken with say they've never seen anything quite like this.
Second Amendment challenges. Rifle and mag bans frequently face challenges in state laws, often on the grounds of an unconstitutional taking without just compensation. While most significant 2A cases are filed in federal courts due to violations of Second Amendment rights, issues related to the Takings Clause are also occasionally raised. For example, in the Duncan, California mag ban case, both a 2A claim and a Takings Clause claim were included. The Takings Clause typically pertains to the confiscation or forcible destruction of items by the government without providing compensation to the affected individuals. However, the recent decision in DeVilliers v. State of Texas, along with the uncertain status of self-executing Takings Clause, may embolden states like California to argue for the dismissal of such claims under the Takings Clause. These types of claims have historically been challenging to win in some cases. Courts often do not perceive forced confiscations and destructions of arms and other items as warranting compensation by the government, or as constituting a violation of the Takings Clause. They may argue that individuals had alternative options available, such as modification or registration, thus negating any claims of a Takings Clause violation. Thus, mounting such arguments already presents an uphill battle. With the added ambiguity surrounding self-executing takings clauses, plaintiffs challenging arm regulations face further hurdles in proving violations of their constitutional rights. Despite the complexities involved, individuals continue to advocate for their Second Amendment rights and seek legal recourse against perceived infringements. That's all for this video, folks. See you next time.